So welcome everyone to a special meeting of the Bennington Select Board. It's February 21st. The agenda for today is that we will go into executive session for confidential attorney-client communication to provide legal advice on pending/threatening litigation. And then we will come out of executive session and we will have one item on our open meeting agenda, and that is a discussion of open meeting law violation complaint. All right, so with that, I'm going to ask fellow board members to introduce themselves.
Hi, I'm Nancy White.
Yes, good afternoon, Clark Adams.
I'm Ed Woods.
And I'm Jeannie Jenkins. And also with us, we have Town Manager Stu Hurd, we have Town Council Merrill Bent, we have Assistant Town Manager Dan Monks, yeah. And I think and we have two members of the public here who will leave during executive session. All right, so could I have a motion to go into executive session?
So moved.
Second? And all those in favor, please say aye.
Aye.
Thank you. All right. Thank you. We are back in public session and we have one agenda item to discuss, and that is an open meeting law violation complaint. And I am going to turn it over to Town Council Merrill Bent to talk us through what is being alleged.
All right, thank you. Yes, I've been asked by the Select Board to address the notice of open meeting violation allegation from Alco Renewable Energy Limited, which was sent by letter to the town dated February 13th, 2025. The allegations are that the town violated the open meeting law by virtue of the fact that its council entered an appearance on behalf of the town in the Public Utility Commission hearing docket for the Apple Hill project. So the town filed a notice of intervention in the PUC proceedings and filed a letter with the PUC on January 9th, 2025, which Alco alleges is an opposition letter, making recommendations in opposition to the project. So a couple things. First, there's clear statutory authority and Supreme Court precedent that's very clear that the town manager has the authority to, in the normal course of town business, direct legal counsel, engage with legal counsel without first having an open meeting with the Select Board. That's something that's routinely done in order to ensure that town process and town business continues without interruption and that the town's interests can be protected. So a notice of intervention in a administrative proceeding in which the town is actually a party as of right is not only authorized, but it was an important exercise of that authority in order to protect the town's interests and make sure that the town had the ability to engage with scheduling and other matters that would come before the PUC before the town even had decided whether it was going to take a position on the project itself. While the town has intervened, and in that process, the town has not, as the Alco letter alleges, has not opposed the project, nor has it made any recommendations in opposition to the project. The letter that was dated January 9th, 2025 has made several requests to the PUC, but there were preliminary matters that were addressed to the PUC primarily because the Planning Commission had asked for more information following the meeting that it had with the developer during the 45-day notice period, advance notice period. The Planning Commission asked that the town staff let the Public Utility Commission and the developer know that it had inadequate information to make a determination about the project. And so town staff did that under statutory authority. The request for information included a request to resolve the question of whether the project should be allowed to proceed because the Apple Hill project had previously been denied by the PUC, and that denial had been upheld by the Supreme Court. The letter requested whether the project asked the PUC to make a determination or hold off on making a determination until there was the question of whether there was a standard offer contract was resolved, because the petition as initially filed said it was proceeding under a standard offer contract that had expired. And the letter also asked for the additional information that the Planning Commission had found lacking, and in that the town actually asked the Department of Public Service to hire experts and other personnel to review the project and make a determination on aesthetics and orderly development. The letter also indicated that the Select Board and or the Town Planning Commission may make further recommendations on behalf of the municipality in accordance with Section 248, following further consideration by those bodies at future meetings. So what it was contemplating was, once the additional information that was identified was received, that the normal process under Section 248 could continue for the town to make an actual recommendation about whether the project should proceed or not. I'm sorry, whether the town wanted to make a recommendation on whether the project complied with the town plan. So that hasn't happened yet. So that we're just not there yet. But given those two bases, given that the two bases for the allegation of the open meeting law violation are in opposition to Vermont statutory authority and the actual letter that the town sent to the PUC, it's my recommendation that the board can take this up and make a determination under state law as to whether there is an open meeting law violation at this point, given that explanation.
All right. Any questions from the board, and then I'll ask for questions from the community that's here. Any further clarifications for anyone from the board? Okay.
I think it's clear.
Okay. Any
I do have
questions?
just one
Okay.
question, because I want to make sure I understand that, and I might not. Are you saying that that letter that the Malones wrote, that Alco wrote, stating that the town, or that Merrill opposed the new Apple Hill project, is that what they're alleging?
The letter that Alco wrote alleges that the town has made recommendations in opposition to the project.
So is that true? And I guess the follow-up is, you said someone authorized you to, or state law authorizes someone in town to do that. So who gave you the authorization to file the opposition with the PUC?
That would be town staff, and to answer the first question, the letter I just described asks a lot of preliminary questions be answered, but it does not take a position on the project.
So it doesn't say the town of Bennington opposes the new Apple Hill project
No,
before the PUC?
no, it does not.
Our letter does not.
Our letter,
But
right.
the Malone letter alleges that we did.
Right, the Malone letter alleges that, but that is
Although
not
that's-
what
Well, aren't they
the,
saying that you did it, the town council, for, that Merrill Bent filed an opposition letter on her own accord, or was pointed, told to do it?
I told you to do it.
All right, so Stu told Merrill to send the PUC this letter of opposition.
It's
no,
not a
it's
letter.
not, there's no letter of
opposition.
opposition.
Okay.
The instruction is to enter an appearance and to inquire about the preliminary concerns raised by the Planning Commission, which was that there was insufficient information, and so there were several requests made to the PUC to answer preliminary questions that needed to be answered in order to determine what exactly the next step of the process would be, what the next step of the process should be, and what the scheduling should look like. And that has had an impact on scheduling in front of the Planning Commission.
And this was allowed
PUC.
without the select board voting one way or the other on any position about the project?
They haven't voted yet.
The town hasn't taken a position on the project. That's correct.
And you were allowed, as town council,
Yes,
to draft this letter.
yes.
Yeah.
Not on my own accord. At the direction of authorized town staff.
Any other questions, public or select board? All right, so then it sounds like we need to make a finding on whether a violation of open meeting law has occurred based on the allegations. Does someone want to make a motion? Either that we do have a finding, or that we don't, or that we find that that the town has not violated open meeting law?
So I make a motion that this board finds that no violation of open meeting law took place.
Okay, is there a second to that?
Seconded.
All right, any discussion? Any discussion?
I don't think so.
Okay. All right, in that case, all those in favor of the motion, please say aye.
Aye.
Any opposition, anyone abstaining? No. Okay. All right. And then, can you succinctly state again the part of the open meeting law violation that they're saying that can you read
Which statute they're citing?
that town staff didn't have the authority.
Well,
to talk with
they're
you.
just citing 1 VSA section 312, which just is a very general statute that says that no resolution, rules, regulation, appointment, or formal action shall be considered binding except as taken as or made at at an open meeting. But there is another statute that governs what that the select board has the authority. The select board has the authority to go forward and engage town council without an open meeting, and then there's yet another statute that says that the town manager has all of the duties and powers of the select board, except for certain enumerated powers that are accepted out of that, which that doesn't fall under. And then there's a Supreme Court case, Heron versus Town of Guilford, which also says that you don't have to have an open meeting every time you want to engage with your town council.
Okay.
Thank
All
you.
right. All right. So then I think for avoidance of any doubt of the process that we're using, it would be, I would ask for a motion that that indicates that expresses that this is standard process and that there is no open meeting violation taking place.
Well, I think you've already had that motion.
Yeah, so actually, I think the motion that I'd
Okay.
like to make is that this board ratifies the action that was taken by town staff.
Okay, yeah,
And
In avoidance of any doubt.
to intervene and participate, to direct town council to intervene and participate in the PUC
That's the action
proceeding.
that I'm referring to, but yes.
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 okay, so, should we restate that?
Let's restate it. I make a motion to ratify the action taken by the town staff to intervene and direct town council to
Intervene and participate on behalf of the
participate on behalf
town
of the town
before the Public Utility
before the
Commission.
PUC.
Yep.
Okay, all right. All right. Is there a second?
I'll second that.
All right. Any discussion?
How does what Ed just read correlate to what the vote is going to be, what Meryl just read? Because you're ratifying something, so what does that mean?
Ratifying the actions that the town staff and town council have taken to signify that the select board is in agreement with them in an open meeting.
So even though we didn't need to be.
Right. Even though you don't need to do that, it's an extra step.
It's an extra step that we're taking.
Yeah,
to
I think
that.
it shows support for and that the actions that have been taken were legal and that we are in support of those actions.
Correct.
Or, if I may speak, I think to let the public know in general that this is how town business is conducted in a lawful, appropriate manner. And that's what went on here, is just day-to-day routine town functions, not requiring an intervention or involvement of the select board on day-to-day activity here in this town.
Thank you.
Well put.
So there's a motion on the floor and there's a second.
Any other discussion before we vote? All right. All those in favor of the motion, please say aye.
Aye.
Aye. Any opposed? No. All right. All right, we have no other business to take up, so I will ask for a motion to adjourn. Ed, you're making that motion?
I am.
I thought she was too. First I saw her raise her hand. Like, yeah, sure, okay.
Are you seconding?
I'll second it since Lee won't.
All right. All those in favor, please say aye.
Aye.
Aye. Thank you very much.